Morning, Your Honors. The matter before the court this morning are the consolidated cases In re 237 Points North Road DRB appeal and In re Von Doring NOV appeal. Case numbers 23 AP 255 and 23 AP 256. Representing the appellant, Stephanie Von Doring, is attorney Harold B. Stevens III. Representing the appellee, Town of Stowe, is attorney Bariah Cushman-Smith.
Thanks very much, and good morning to both counsel. We'll hear from counsel for the appellant first. Please introduce yourself, identify your client, and then proceed.
Good morning, Judge. Harold Stevens for the.
We can't hear you.
You can't hear me?
Now that's better.
Can you hear me now better?
Yeah, that's better. Yeah.
Okay, it's attorney Harold Stevens for the appellant Stephanie Von Doring. This appeal is about the violation of a setback at a residence that's on Points North Road in Stowe, Vermont. Basically, her lot is a key-shaped lot, irregularly shaped, which initially the front yard of the lot was Route 100, and Points North Road was the driveway to get to the house. In 2004, the property was subdivided, and the house was built 50 feet from the Points North Road, which had been the side yard of the property for years, and Route 100 had been the front yard. And my client built a pavilion within the side yard setbacks, 50 feet, but the town's now saying that the Points North Road should be the front yard. And we hired a surveyor who testified that the front yard is where the tip of the key comes into the center line of the road. So basically her lot owns to the center line of the road, making that the front yard. And to top it off, Vermont Stowe's zoning regulations require that side yards and front yards be set forth on the subdivision plans. And this was not done by either the subdivider or the town. So the approved survey, which we've provided you with from 2004, shows that. So basically the appeal is that there should be a declaration that the court erred in finding that Points North Road was the front yard as opposed to the side yard to this house.
Okay. All right, we'll turn to counsel for the appellee. Please introduce yourself, identify your client, and then proceed.
Mr. Chief Justice, and may it please the court, my name is Bariah Cushman-Smith, and I represent the town of Stowe. This appeal asks you to decide whether the Stowe Zoning Administrator, the Development Review Board, and the Environmental Division were correct to find that the as-built unpermitted 900 square foot pavilion on the appellant's property is not eligible for a permit because it is built within the front yard setback as defined by the zoning regulations. The property in question is known as 237 Points North Road, and in the property zoning district, the front yard setback is 70 feet from the street line. Now, the zoning regulations define the front yard setback as the distance from the street line to the closest portion of any structure, including roof lines, porches, and sills, except steps. The appellant does not dispute that Points North Road is a street, nor does she dispute that the pavilion is closer than 70 feet to Points North Road. What the appellant disputes is the town and the Environmental Division's interpretation of the definition of street line, which the regulations define as the line dividing the street right-of-way and the lot. The town's and the Environmental Division's interpretation is that the street line is the line dividing the street right-of-way and the lot. Or in other words, the shared boundary of Points North Road and the appellant's parcel. If the court's at all sympathetic to Mr. Stevens' argument that this definition is ambiguous, any perceived ambiguity is clarified by the zoning regulations definition of setback as the shortest distance between the nearest portion of any structure on a lot and the edge of the road right of way, a shoreline, or property boundary. And here,
Is this a math problem as to where to start the measurements from?
there's no math involved here. The only issue, because the appellant agrees that the pavilion, the unpermitted pavilion, is built within 70 feet of Points North Road. The appellant's interpretation is that no, the front yard isn't measured from the boundary shared with Points North Road. It's from the southern boundary of the road facing Route 100 if looking from at the map. The Environmental Division called this interpretation one that strains common sense. It would actually make all properties with frontage on a road would then have 2 front yards, because the way the appellant is describing the street line is where the road perpendicular meets the boundary of the property in a perpendicular way, and that interpretation just doesn't work throughout the regulations. If you control F the zoning regulations and try and insert the appellant's interpretation into any place where the term street line is used, you come to an absurd and unworkable result with creating onerous regulations with 2 70-foot setbacks in this zoning district. The correct interpretation and the clear interpretation is that the front yard is measured from the street line, which is the boundary shared with the road that the property is on.
Okay. You have 1 minute. Anything more?
The history that Mr. Stevens brings up is irrelevant, and because nothing in the zoning regulations asks us to look at the history, it asks us to look at the property the way it's situated today with a proposed project today. Front yards can change through subdivisions or an addition of a street. A corner lot can have more than 2 front yards, as described in the zoning regulations. Because the regulations are clear of how to measure this setback, we request the court uphold the environmental decision in case the Environmental Division's decision in case number 23 AP 255 and dismiss case number 23 AP 256 as moot, as the appellant has conceded in the briefs.
All right, thank you very much. We'll turn back to the appellant. How much time does the appellant have, please?
Appellant has 2 minutes and 54 seconds remaining.
Counsel?
Looked at the survey of this property, but if you look at the survey and the tip of the key, basically where the lot, since the lot owns to the center line of Points North Road, where the road first hits the lot is facing Route 100. And you can argue, I understand the town's argument, but we've got a surveyor that says that's where the lot first meets the street. And the problem is that in this type of case with these types of irregularly shaped lots that own to the center line of the roadway, it's not clear exactly where the front yard should be. And if there's any ambiguity, it should be decided in my client's favor. This is going to cost her hundreds of thousands of dollars to bring down this pavilion, which is the same setback from the road as the existing house. So they're saying, so basically, is the existing house already in violation of the setbacks? It doesn't make any sense when you talk about
Stevens?
yeah.
Mr. Stevens, but doesn't the zoning regulations the plain language of the zoning regulations is to use the closest place to the road.
Where
So,
it first meets the lot. And so, yes, that does, but where it first meets the lot is, here's the center line of the road, and here's the lot going there at the tip. So that's where the road first hits the lot. This is an unusual case because usually lots don't own to the center line of roads. The road is usually a separate, usually owned in fee simple by developers. In this case, the developer developed the property so that each
You have
lot
1
owns
minute.
to the center line. So
You
each
have 1
lot
minute.
owns to the center line. That's what's confusing. And and I'm just saying, we've got a surveyor that testified that that's the front yard. And they don't have an expert. They don't have a surveyor. And the weight of the evidence was in my client's favor. Thank you.
Okay, thank you. Thank you both. Please call a conclusion of the hearing.
The next hearing for the court is scheduled for 1 o'clock this afternoon.